Olá, bom dia a todos. Eu só vou colocar aqui né? Colocar aqui só a live. Ana Nylund. Nylund. Yes. Olá, bom dia a todos. Nós estamos aqui com a professora Ana Nylund, que já está entrando aqui para a gente começar a nossa live, primeira live internacional do projeto Mulheres no Processo Civil. Vamos ver aqui se a professora entra. Professora. Vamos aguardar aqui ela entrar. Yes, we got it.
Yes.
Hi, Professor Anna. How are you today?
Thank you. I'm fine. And you?
Great, thank you. It's a great pleasure to have you here with us.
Thank you. It's a pleasure.
Thank you a lot for accepting our invitation. And I hope you're well in Norway. And we're going to start in a few minutes. I'll just wait for the people to get in the live. And before we start, I'll have to make some announcement for the people. I'll have to introduce you and make some announcement. And then I come back in English to talk a little bit about case management. Is that possible?
Yes, that's very fine.
Ok, thank you. Bom, pessoal, muito bom dia. Meu nome é Tricia Navarro, eu sou do Espírito Santo e eu estou aqui hoje a convite, né, do projeto Mulheres no Processo Civil para a gente conversar um pouquinho com a professora Nylund, da Noruega, sobre case management. Eu quero dizer que é uma honra estar participando desse projeto, participando dessa primeira live internacional do projeto Mulheres no Processo Civil. Para quem não conhece a professora Ana, ela é professora da Universidade da Noruega, ela é uma estudiosa do case management e ela tem como principais áreas de estudo o direito processual comparado, ela gosta muito também de métodos adequados de resolução de conflitos. Quero saudar todos os nossos colegas que estão aqui, especialmente o professor Antônio Cabral, que acabou de entrar. Agora a gente fica um pouco mais nervosa, né, Cabral? Mas é uma honra tê-los aqui conosco. Então, ela é uma estudiosa no direito processual comparado, nos métodos adequados de resolução de conflitos, ela estuda também direito de família. Ela participa de diversos conselhos e associações na Europa, como a Associação Internacional do Direito Processual, a Academia Internacional de Direito Comparado. Ela tem diversas obras, artigos, e livros publicados, tem 7 livros publicados. Ela tem um artigo que foi publicado sobre esse tema que a gente vai conversar com ela hoje, na Repro, foi publicado em junho de 2019 na Repro, chamado Case Management in a Comparative Perspective, Regulation Principles and Practice, publicado em junho na Repro. Então, ela é uma estudiosíssima no assunto e eu estou muito honrada de ter sido convidada para fazer essa intermediação dos debates. Antes da gente dar início à live, eu quero dar um recado para vocês. Logo na sequência dessa live, às 11h15, nós teremos uma outra super live do Projeto Mulheres no Processo Civil, com a Chiara Ramos e com a Adriana Cruz, sobre a mulher preta na academia jurídica. Esse é um projeto incrível também que o Mulheres do Processo Civil, elas estão agora também encampando. Então, eu convido a todos para 11h15 estarem presentes nessa segunda live. Então, dito isso, e sem mais delongas, eu vou agora voltar em inglês para a professora Ana. Ela vai falar, a palestra toda dela vai ser, a live toda vai ser em inglês. E no final eu vou tentar fazer um breve resumo em português para vocês. Tá bom? Aproveitem aí, agora eu volto em inglês. Yes. Great. Now we are back. So, Professor, we're going to talk a little bit about case management. I love this theme. And the first question that I'm going to ask you is how case management can be defined and what the term encompasses.
Thank you. Because we talk a lot about case management, I think, and we use it in many different contexts.
Mm-hmm.
And I would say that there are three aspects of case management, and they're interlinked. And one is administrative case management, one is procedural case management, and the third one is substantive case management. And the administrative case management is more detached from the two others. The two others, procedural and substantive, are more interlinked. And I'm going to talk about those. But first, let me define administrative case management. By that, I refer to mainly to distribution of cases among judges in a court. So which judge is going to hear this case? It might be a specific order of that everybody, first judge 1 gets the first case, judge 2 the second case, and so on, and then we come back to judge 1 again. Some countries, some courts allow systems where judges specialize partly, that some type of more complex cases, for instance, are assigned to certain judges. It might also be their experience. If you have a very complex case, you might not put your most newly appointed judge to hear that case and administer it. And sometimes it might be a matter of personal inclination, where some judges love complex cases and some simply hate them. Some judges hate some types of cases, and another one might love to sit that case. And then the court administration, to some extent, can then take that into account. Administrative case management has also, I would call it a new public management aspect to it. You count the number of cases, you count the time used, etc. And while I must say that is to me important, I think that the problem of it is the fallacy of counting what's easily countable. Not everything that is easy to count, like the number of cases, counts, is important. And then again, not everything that's important is really easy to count. And that might, if we push it too far, we might lose the quality aspect of justice. So the two other forms of procedural justice, number 2, procedural justice, what I'm talking about, case management. The procedural case management is about taking the right procedural steps. It's about managing the proceedings. Traditionally, it has been joinder of cases, setting time limits, and also deciding when to keep hearings. But today we see much more diverse topics, much more which form of proceedings, because we have class actions, we have small claims, we have more mixture of written and oral proceedings. We also see evidence. Should we allow access to evidence or compel somebody to give access to evidence, experts, etc. And of course, timing and those kinds of questions. And then we have substantive case management, and that is, I think, the newest aspect, because in that we try to concentrate the case to identify the core disputed factual and legal issues. So basically narrowing the case down to its very core. And procedural and substantive case management are very much interlinked. Because, for instance, if you think about assigning a case to class action or perhaps proceeding with a pilot case, you would need to know whether, for instance, the main disputed issue is the question of liability, or whether it is how much you should pay for a broken arm or a injured or a damaged laptop. Because those will be different probably. If it's, let's say, an accident, it will be different for everybody.
Mm-hmm.
But the question of whether, for instance, a bus company after the bus accident is liable is common. And so those are really very interlinked. And I think that it's important that we realize that they're interlinked, but they're also different things. And what's more to it, particularly to the substantive aspects of case management, is understanding how law, facts, and evidence is related. Because why would we use a lot of time on an expert if the factual issue is not disputed, or it's very peripheral to the case? It's not really a central question. Then we would use much less money and time on the evidence. So deciding on the proceedings, we can only really make sensible decisions if we know what the case is really about. And also, if we know what the case is really about, what we can do then is we can understand how to put the timeline of the case. Because if we realize that, okay, this is a really big case, but actually the disputed issues are small, and so complex, then we can move on rapidly, and the other way around. And also, if we use a lot of money on things, evidence and arguments that are not really relevant, then we lose the case, or we lose a lot of money. We use it, and we use the time of the judge, the time of the parties, the lawyers, everything.
And it can be expensive, though.
Yeah, it can be really expensive. And what's the worst thing? If we don't know the core of the case, we will draw in a lot of things that are not really important, which means that the judge or judges, the panel of judges sitting the case, they will have a hard time figuring out what are the relevant facts, what is actually the law, what is the main legal question that they have to address. And they get confused by listening to all this stuff that has very little to do with the thing. So we can say money, we can say time, we can actually, I think, also come to the correct outcome, both factually and legally. And even, I think people will feel more heard if they understand what their case is about. So they will perceive justice much more if they understand that this is actually, as your lawyer, I need to focus on these things because these are the main issues. And the judgment is probably going to address those issues in a way that also makes it accessible for the client.
Yes. And why case management is a global trend right now? What do you think about it?
I think it really is a huge trend, and you can see that it's, or maybe not just a trend, but more that we really realize how important it is. And I think it has to do with sort of, because all legal systems are currently under pressure, too little money. Even in a country like Norway, our courts are under-financed. And our civil proceedings last too long, they're too costly, even though we have, compared to most other countries, short processing times. They're still considered too long. And then I think it's also about flexibilization. We have many more tracks, and also contractualization, or if we can put it like that, so that the parties we give them more room to be involved in the proceedings. And I also think it has to do with the fact that the so-called main hearing model of civil procedure is proliferating. Much more countries are adopting it. So we have an initial stage where the case comes in, the statement of claim, and we control it, and then we serve it upon the defendant. And then we think that the hearings or the proceedings will end with a main hearing, where we try to concentrate the hearing to one day, or if one day is too short, to a few consecutive days. And then we also try to concentrate the case so that we only hear what's relevant in a single oral hearing. And to be able to do that, we need a preparatory stage, and there we need really to manage the case so that it gets boiled down to a format where everything is concentrated as much as possible. And to do that, we need case management, in addition to what I said about the tracks. And I think it has, you can see this, that it's been spreading. Germany and Austria were some of the first countries that had this kind of really put a lot of emphasis on case management that happens during the preparatory stage. But you can also see that England and the Nordic or Scandinavian countries have strengthened their preparatory stage. We can see it has been adopted in Spain, Brazil, ELI, UniDroit rules that will probably be might be adopted this summer. So the European Law Association and UniDroit have adopted a model law of civil procedure, and it's also built on this one, as well as the American Law Institute and the UniDroit principles for transnational civil procedure. And they're based on ideas of concentration, both in time and in scope of the case. So you try to boil it down really to the core disputed issues, as I've said. It's about clarification, that you clarify what the parties mean and what the case is about well in advance of the main hearing, so that nobody can accidentally or by design, you can postpone things and only introduce new things at the main hearing. So we don't want to see that. It's called trial by ambush, when you wait until the main hearing and then just throw things in.
Yes.
And we know that the outcome is never good, at least not for the other party, and usually not for the court either. And then I think the principle of cooperation, that this is not a gondola. My colleague Aleš Galic said, where there's only the gondola guy who rows, and then there's the couple who just sit there and enjoy each other's company. This is a rowing regatta where it's 1, 2, 3, 1, 2, 3, and everybody needs to do their work. And also the concentration part, that you really think that this is a game of volleyball. You touch the ball 3 times. First time, it comes over the net. The case comes to the court. The second time you touch it, you prepare for it to be sent back over the net. And the third player hits the volleyball. And this is the same thing. You have the initial stage and the preparatory stage, and then you have the final stage.
Yeah.
And then, of course, I think there are a lot of things that, if you could say, that have happened in civil procedure, and I already mentioned class actions. I mentioned small claims. We got idea of ADR that needs to be interlinked into civil proceedings. We need to find better balance between written and oral issues. We have more countries have rules on disclosure of evidence, and then you really have to know whether you must or should or could compel somebody. We have the technological advances that suddenly you can say, in the old days you would kill somebody with a library like mine, because finding something there is terribly difficult. But today we can also kill someone by giving them access. If I give you access to my computer, all my files, and you don't know which keyword to use, you will have to look through all files I have on my computer, and you will not find it unless you have the right keyword. And of course, if we're going to use energy and money and time, resources on that, then we need to know whether it's appropriate to do that in this case. So I think those are reasons why we simply find out that it's really necessary to have case management, because otherwise nobody can live with this system, and we cannot make use in a meaningful way of the tools that we have.
Yes, that's what I was going to ask. Which case management techniques seem to be successful in your view?
In my view, well, first of all, I think very much that you have to approach case management differently depending on your case. I think Norway has had this idea of a very short case management hearing, and I think it's always remotely, so mostly on telephone. And I think during the past few months, judges have realized that you can actually interact with people face to face too. But anyways, yeah, and it's with usually only the legal counsel. And it's usually half an hour. They schedule it at 9 a.m. So they have hearings at 10, so it will last about half an hour. And then there they discuss very much timing, schedules, and stuff like that. And I think that's a very good tool if you have either a very complex case or a simple case. But it doesn't do for middle cases. And the reason is that this is the kind of technical hearing, and the assumption is that you know what the case is about, that you don't need substantive case management. So you have only the procedural aspects of case management. And I think in Norway, this has to do that when the Civil Procedure Act was reformed, we went to England to get ideas from there. So it's very English. The problem is then if you have other issues that you have to clarify the case, it's not really clear what the scope is. It's not really clear what the core disputed factual and legal issues are. Then you should have a preparatory hearing where you really discuss the case. And we're currently suggesting a reform of civil procedure where we try to make judges expand the case management hearing into a real preparatory hearing. That's what's done in Sweden and Finland, where there's a German system, basically, where you have this hearing where you're supposed to discuss the case to identify the core of it, and then draw into also the procedural questions. So I think that's very important. And additionally, you, of course, might need a more preliminary hearing where you decide on jurisdiction or to strike out a case or choice of law, make more decisions on substantive or procedural topics. Also, it's of course very important to set time limits and to enforce them. Countries like England and Norway, where judges are not too much enforcing time limits, we see that people don't obey. Sometimes you need to be harsh. And also scheduling is important, that you try to discuss where and when and how to proceed, and also put a time schedule. The European Court of Justice, the Court of Justice of the European Union, they're really strict with timing main hearings, and they will really shut off your microphone. And because there it's a multilingual process, the problem is that if they shut up your microphone, the interpreter won't hear you, so you're in trouble. And then summaries are a really important tool, and we're also trying to get the Norwegian judges to start using summaries because they're used in Finland and Sweden. And that means that the judge writes a 1 to 2 page summary of the case, really outlining this is the background of the case. And these are the main disputed issues, both legal and factual. And these are the main legal arguments and main factual arguments of the parties. And then attached to that, you can put a list of evidence. And what this document does is that it forms the backbone of the proceedings. So when the judge sends it, usually a few days before the preparatory hearing, And then the parties can say, because it's only have I understood correctly type of document, then the parties can say, no, actually we disagree on this one, or I actually agree with the other party on this issue. And then the judge can also say, do I understand correctly? Would you characterize this contract as, let's say, purchase goods, or would you characterize it as a purchase of services? And that enables you to sort of understand what the core is. And then that also enables you to assign it to a certain track, to look like what's the evidence that's needed, that's relevant. If you realize that this factual question is not really that relevant, then you can ask the parties, why are you going, is it really necessary to hear 5 witnesses? Or to say, what will this witness testify about? Which of these disputed issues? And then the parties might say, okay, let's strike out that witness. We don't really need that. Or maybe, it's a 2 million whatever case. And then the judge says, well, based on this, it looks like actually the dispute concerns 400,000. That should we really use a lot of money on this expert? Because this is really about 400,000.
But has the judge, does the judge have a power to do that in Europe or in Norway?
Well, judges will want to have the parties to strike witnesses out. So you wouldn't say most judges don't really like to strike out witnesses. Norwegian judges would basically never do that. And in none of the other Scandinavian countries, I think a judge, they would be very hesitant. But when the judge says, is this really, asks you those kind of questions, you might say, yes, I really think this is important, because I think these witnesses will, there can be some reason why 1 isn't enough or 2 isn't enough. It might be a question, it was so long ago, so they might not remember, and you need more, or they will testify about different aspects.
But at the end, it's the party's decisions. It's the party decision.
Yeah, but the party will also know that if this is too much, then the judge will probably say that you cannot have all your costs covered.
It's all about cooperation, right?
Yeah, it's all about cooperation. Yeah, and the same thing that the judge is also, when the judge brings the summary, the judge says, I might be wrong. This is my interpretation. And also when the judge, you wouldn't want to be partial, right? So you would try to, you would never suggest, look, to me, this isn't a purchase of goods, this is purchase of services, but the judge would say, would ask, try to frame it as questions that would lead the parties to say, well, maybe this could be characterized differently, and then realize that maybe I then need to gather other arguments, whether legal or factual. So more of a discussion where this is again the rowing, where everybody needs to do their work, and the judge doesn't know the evidence, the judge doesn't know the background of the case.
Yes. In Brazil, the judge has a power to do that, to strike out the evidence. Yes. And talking about ADR, what do you think how is ADR related to case management?
I think in very many ways. One is some countries like Norway and England have pre-filing obligations. So this might be at the time to check in on the parties and saying, okay, have you fulfilled your pre-filing obligations, usually negotiating, or it might also be mediation. And then if they haven't, you would suggest they do. Even though, for instance, in Norway,
it's mandatory or suggesting?
It's mandatory to negotiate, to attempt negotiation. But you know, how much good faith is it in there? And the sanction in Norway for not doing that is just cost sanctions. But also, you know, that you're, so to say, pissed off your judge. The judge won't be very happy, and then the judge will gently try to suggest you try negotiation. But sometimes, of course, we know that mediation, negotiation, ADR, it's a matter of the case maturing or the parties maturing. So even though it was unsuccessful and they were very reluctant before, they might be much more inclined to do so. So I think that's important. It's also very much important to understand, should we assign this case to ADR now? And if you have a different kind of processes, ADR processes available, you might want to case management and discussing the case with the parties can tell you if it's appropriate and which process is appropriate. Let's say for some cases you would probably benefit from neutral evaluation because it's a technical issue, right? So you would, or evaluation of the value of something. So let's say it's an important piece of art and one party says it's worth a little and the other one says it's worth enormous amounts of money, and then you could send it to neutral evaluation, and the evaluator gives you then the sum that you could use at least as a starting point, and that would probably help the parties to negotiate a deal. And sometimes like mediation might not be appropriate if one party has much more resources, knowledge, etc. Or you would want to consider different mediation processes. Of course, it depends on who pays for it, how it's organized, etc. And also, I think what's important is that judges can promote mediation and facilitate settlement themselves.
Oh, really?
Yes, and that's very common.
Does the judge can participate on the mediation?
We have sort of dual systems. One is that it goes to court-connected mediation when it sort of switches out of the litigation track to mediation, and the same judge then continues to mediate. This is typical in Scandinavia. And but there's also that you sort of take off your robe as a judge. You're not the judge anymore, you become the mediator. You can also assign it to a colleague. But once you are mediator, you cannot return into the role as a judge.
Oh, okay.
Yeah. But you can also facilitate settlement within. As a judge, you can, for instance, what you would do is that you could pinpoint the difference. You could say, okay, we know that this contract is worth 2 million. But your dispute is really about 400,000. So it's about this 400,000 gap we're talking about, not 2 million. And maybe it would be possible to find agreement. And you could then go on saying that, listen, to figure out this 400,000, we need an expert probably. And the expert is going to, you need to stop the machine that you're talking about. The expert is then going, it doesn't work. The expert is going to open it, is going to see what's wrong in it, and is then going to assemble it, and it maybe still won't work. And then we'll continue with litigation, and that will cost you a lot of money. And then you will find out the answer. Or you can fix the problem and figure out who pays for it. It will take much less time. Some of the costs will be the same because you have to stop the machine that isn't working properly. You have to disassemble it. But instead of you find out where the problem is, but then you can go directly into fixing it, close the machine, and it will work perfectly. And you will save money, you will save time, etc., the stress, and you can ask them about litigation risks. For instance, how much does it cost you if your CEO needs to be here in court for 2 days? How much does it cost you to prepare for the expert coming, the rest of the main hearing, evidence, everything? It's going to cost you so much money that it will be much cheaper. Or you want to suggest to them, if we are like here in Tromsø, we've got 8 meters of snow this winter. So we have these disputes about snow. When you move it away from your driveway, it might end up in your neighbor's yard.
Mm-hmm.
And this problem, usually we only get about 4 meters of snow every winter. So this problem is going to arise every single winter. And even if we solve it here right now, you will still have a problem because your neighbor might put it in a place where he or she is allowed to put it, but you don't like it. Or you can go to mediation and find out a solution that's good for both of you. And in that way, understanding what the case is about, for instance, between neighbors, that it's really about finding a good place to put your snow. It's not about anything else. Then the judge can really facilitate settlement. And even the parties can even there, with the help of the judge, because then the judge doesn't have to say anything about law, because he or she understands that this is about the snow. So he or she can actually facilitate, cannot send one party out of the room just to be with the other party, but having them both there saying, then facilitating agreement.
Do you call it conciliation or not? Is there any difference about conciliation mediation?
No, we don't.
Norway?
We call it actually, I like to call it in English, judicial promotion of settlement or facilitation of settlement, because that is what you do. And I think if we call it conciliation, we might, many people refer to what I would call evaluative mediation. And I think when we talk about ADR, it's highly problematic that we don't have a standardized language for it.
Yes.
Neither in English nor in, for instance, Norwegian.
Oh, great. What's the number of mediation in Norway? Is it high?
The number, I mean, we cannot really compare Norway and Brazil for 2 reasons. One is that Norway has a population of 5.4 million. So in many of the big cities in Brazil, there are far more people. There are more people than in the entire Scandinavia, in places like Sao Paulo. So,
but comparing
and also,
with the number of the cases of the process.
Yeah, we have very, very few court cases. When I was in Rio a few years ago, I counted that if you had as few cases as we had, you would have 500,000 cases annually in your courts. 500,000, so almost nothing. And of those, 70 to 80,000 would go to mediation, court-connected mediation. And of the cases that come to courts, only 1 of 3 goes to a main hearing, and approximately 1 in 3 cases will settle, whether in court-connected mediation, mediation outside the courts, the judge facilitates a settlement, or the parties just negotiate a settlement any time during proceedings. And it's not uncommon for cases that do not settle in court-connected mediation to settle before the main hearing. And about 2 in 3 cases that are sent to court-connected mediation settle.
Oh, it's good.
And these figures are the same in Finland. So Finland and Norway are the countries in Europe with the most court-connected mediation, and the countries with among the highest settlement rates, and it's not mandatory. And the 1 in 3 cases to settle is approximately the same as in Germany. So Germany has also very high settlement rates.
Oh, okay. And what do you think about Brazilian case management?
I know too little about it.
You wrote a great article. I was just talking to the people that you wrote an article that was published here in Brazil last year called Case Management in a Comparative Perspective. So it was great. It was a very good article. And you talked about Brazilian case, the Brazilian system. So what do you think a little bit about I wrote, but I want to
Of
tell the
course,
people.
it's since I don't know your practice, it's very difficult for me to say. But the text, the regulation, the text of the regulation, I think is very much state of the art. There's this a clear provision on procedural case management, and a little less clear provisions on substantive case management. And that is not a surprise, because procedural case management, we have, for instance, the English model, and it's very easy to write that the judge has to consider and manage a case and consider setting time limits, which evidence will be allowed, whether it shall be assigned to this and this track, joinder, all these things, and you can list them very easily. But when it comes to substantive case management, that's really problematic, because there is no really good example, sort of a blueprint you could follow. The only good blueprint I've found so far is actually in Swedish law. And I also see the ELI, Unidroit model law, so the European model law, that will, the ELI and Unidroit might, we don't know, they might accept them, but they will be published this year, whether they will endorse them or not. But there you actually see how even that group of experts strive to make a good rule on substantive case management. And they've broken it into parts, so you find a little bit here and a little bit there. And I think they use a language that might be problematic for many people, because they say that the judge can advise. And I think that people like me say, like, the judge can never advise anybody. You cannot do that, because you have to be impartial. Yes, but I think it has to do that it's a copy of German law. But I think your rules are more, it's soft language, and it's more, the German rules are also very old. It's more up to date, and sort of trying to find a way to regulate it, because obviously so many countries have attempted to regulate it that it's very difficult.
Yes. And well, we are going, we are almost ending, but I would like to talk a little bit about proceedings agreements, the contractualization of the proceedings. So what do you think about it? Can the judge participate on this agreement or not about proceedings? Because here it's a discussion about it. If judge can or not participate on the settlement, on the proceeding settlement with the parties.
Scandinavian law says the judge can't. Scandinavian practice says the judge shall and can. So yes, theory doesn't mean practice, because and I think the old-fashioned way is to say no. But if we think that, as I mentioned, cooperation is a key principle, and we want to sort of, this case management is about tailoring the proceedings to fit the case. Yes. And who knows the case? Yeah. And I think, of course, the judge must always make sure that the stronger party, the party with more resources, if there is imbalance, doesn't sort of just simply kill the case of the weaker party, and that there's a fair trial, that there are these basic principles. But apart from that, I think they can be really helpful, and they actually align very well with the ideas of tailoring proceedings, of flexibility, and also of cooperation. And I think that the current situation is also really shown how useful those can be. For instance, we have a provision says that you can have written proceedings if it's appropriate and the parties agree. You can, it's much easier to conduct remote proceedings because even though we have foreseen remote proceedings, nobody could foresee that the judge sits at home and the parties sit at home. But we know this is facts. And if the parties agree, if they say, I want my case to proceed, and I'm okay with remote hearing, then it's much easier to force the parties into it. And if the parties request written or partly written or fully remote proceedings, go ahead.
Oh, great. I think that the judge can participate in this customization of the proceedings, but here we have some resistance about some authors. So to end, I want to make you our last question. What do you think is the future of the case management in the world?
Well, of course, it's difficult to say. Yeah, it's really difficult to tell.
That's why it's the last question.
Yeah, I think actually, I really hope that this is a path that we will move forward on, because I believe that is the only way that we can keep civil proceedings accessible to people. Because currently it's costly, it's time consuming, and if we can make the proceedings appropriate, so fit the case, fit the individual needs of the case, then we can also offer cheaper, better, faster justice. And also if we realize that the parties need help of the judge to find the core of the case, I think we could develop new methods of doing that. We could have with the statement of claim, you could already file a draft summary, and then you would force the defendant to write into the same document. You could have this online if you have an online intake system, that you use this one single document as the summary, and that's you keep on editing and updating it throughout the proceedings. And that could be the core of case management, because that document will tell you, sort of give an indication of how to proceed procedurally, how to proceed with evidence, how to proceed with your arguments. So we could use new technology also, even to enhance case management much more than what we do today. Because what we've learned in the past few months is that we can do miracles when we want to.
Yes, for sure. How is the technology in justice in Norway in this pandemic crisis?
Both good and bad. Our courts have had some of them have had very, very old-fashioned systems, and it's sort of a little bit ridiculous, because we have paid for poorer European countries to have, for instance, recording equipment at courts, so where you would get sound and video of the people, and those have not been installed everywhere in Norway, whereas we have paid, for instance, for Lithuania to get them. But still, of course, I mean, Norway has high-speed internet and computers almost everywhere, so I think we have faced much less problems than almost the most other countries. But there has been a huge variation among courts and judges in how much they're willing to make use of new technology. And we have seen courts where there's been a couple of judges who are really enthusiastic and who teach their colleagues to use it, and some places have just simply shut down their operations.
Oh, great. So, Professor, I'll thank you a lot about your information. It's a good it was a great presentation, but now I want you to wait a little bit. I'm gonna do a little summary about all the thing we talked to here, and then I come back for the last words. Ok? Ok. Bom, eu vou fazer espero que vocês tenham gostado. Eu acho que para mim foi super importante essas palavras da professora Ana. Eu realmente aprendi muito com ela e achei sensacional. Eu tinha várias dúvidas, que inclusive perguntas que eu não tinha feito antes da live para ela. Ela acabou me esclarecendo aqui durante a live. E, em resumo, ela sobre as 5 perguntas básicas que eu fiz, ela disse o seguinte, que ela entende, né, a Catarina, ela foi durante a live fazendo alguns apontamentos, fazendo algumas traduções do que foi dito, mas, basicamente, ela acha que o case management, eles têm diversos aspectos. E ela cita 3. Primeiro, o administrativo, sobre o número de processos, sobre as questões, sobre como tratar o número de processo, o tempo do processo. Depois ela vê um aspecto processual, que é muito importante, que é você identificar qual é o procedimento adequado para cada caso concreto. E também tem o substantivo, que ela fala que aqui no Brasil a gente cuida pouco do aspecto substantivo, do case management, que é as partes e o juiz identificarem corretamente a lei, os fatos, as provas, antes da audiência principal, para que o procedimento ele tenha racionalização e para que as partes elas sejam mais diretas, para que as provas sejam mais diretas e sejam mais adequadas também, para a gente não perder tempo e nem custo com o processo. E para que as partes também fiquem mais satisfeitas. Ela falou que o case management é uma tendência mundial. Em vários ordenamentos jurídicos, eles estão implementando o case management. E citou que principalmente a questão da flexibilização do procedimento, técnicas como flexibilização do procedimento, que nós temos aqui no Brasil muito forte, a contratualização do procedimento tem sido também aplicada. E o que ela acha muito interessante é haver uma fase preparatória para a audiência principal, para que nessa audiência nós tenhamos bastante racionalidade na oitiva das partes, das testemunhas, dos peritos, e isso depois vai refletir diretamente na qualidade das decisões judiciais. Então, ela falou muito nessa preparação, nesse dever de esclarecimento, na cooperação entre as partes. Ela disse que as partes elas têm como se fossem umas alegações finais nossas, elas fazem um resumo antes dessa audiência para que o juiz identifique se os fatos e o direito, se eles estão identificados. Falou muito sobre o uso da tecnologia, que a tecnologia ela tem sido implementada cada vez mais na Noruega e também em outros países. Ela acha que isso é o futuro também na aplicação do case management. Falou do calendário procedimental, que agora a gente tem aqui também, né, no artigo 191 do CPC. Ela acha muito importante essa questão dos limites temporais, ou seja, é muito importante que todas as etapas a gente tenha limites mais definidos, que a Corte Europeia é bem rigorosa com o tempo, que ela corta o microfone quando alguém está falando e ultrapassa o tempo. Que esse resuminho que as partes fazem, ele geralmente tem 1, 2 páginas no máximo, antes da audiência, que é bem sucinto. Falou que a conciliação e a mediação está sendo bastante, tem total relação com o case management e está sendo bastante aplicado lá. E aí, é claro, eu não poderia deixar de perguntar sobre a participação do juiz, né? Como é que fica a participação do juiz? E ela disse o seguinte, que o juiz, geralmente lá, o sistema de mediação, ele é bipartido, né? Existe um tipo que a gente tem hoje aqui como Sejusc, que faz a mediação, e que o juiz depois decide o caso. E se o juiz sugere a mediação e as partes não concordam, isso depois vai ter um efeito, eles vão pagar mais custos no processo. Então, lá assim, as partes não são obrigadas a fazer a mediação, mas se elas não fazem de má fé, se o juiz não percebe má fé, isso pode ensejar aumento de custos no processo. E falou que o juiz ele pode fazer a mediação desde que ele não julgue. Então, esse é o sistema. Mas o juiz ele pode facilitar para que as partes cheguem a um consenso. Esse é lá também é considerado um dever do juiz. Ela falou sobre o nosso procedimento, que ela em relação à questão procedimental, case management procedimental do Brasil, é bastante avançado, mas ela não ficou muito claro para ela como esse aspecto substancial que ela adota, como que se isso ficou muito definido aqui no Brasil. Sobre o futuro do case management, ela acha que isso vai proporcionar mais acesso à justiça, porque isso vai dar mais proporcionalidade ao uso racional da justiça. Então, foram essas, basicamente, as perguntas. Perguntei também sobre se o juiz poderia participar das convenções processuais. Ela acha que uma visão mais antiga entende que não poderia, que o juiz não poderia participar, mas ela acha que a tendência, e que ela também defende, que o juiz deveria, sim, cooperar com as partes, com as convenções processuais. Então, essas foram as palavras. Esse foi um breve resumo sobre as muitas informações que foram passadas nessa live. Então, eu vou voltar para ela para que ela fale as últimas palavras. Professor, I made a brief summary of your words. So, I want to thank you a lot to be here with us. It was an honor to have you here. Thank you for your availability to talk with us. And if you want to say some last words, you can talk.
Thank you for inviting me. It has been an honor and a pleasure to speak with you today.
Yeah.
And I hope we see each other live
in Rio,
sometime in the future.
I hope I'll see you soon in Rio.
Yeah.
And it was a pleasure. I hope you enjoyed. Sorry about my English if I made some mistake. And I hope you see you soon. Take care. And thank you very much for your time to be here with us. It was a pleasure.
Thank you.
Thank you very much. See you. Bye-bye.
Bye.
Bye.